Hi, I'm Jim Posner, and this is the Don't Panic Project. We provide engaging conversations to help empower, inspire, and educate people suffering from stress, anxiety, and depression. Today's guest is employment lawyer Alexander Sakin. Now, before we get into our intro of Alex, I just want to talk about why we have an employment lawyer here today on the Don't Panic Project. On the Don't Panic Project, we're always looking for methodologies of helping people alleviate root causes of stress and anxiety. And I would say it's pretty hard to dispute the fact that work is a large generator for a lot of stress for a lot of people. And so Alex will help us explore some different scenarios that people may be going through at work and how they can best deal with those without creating more stress, and in fact helping them to alleviate some stress and going about it, legally and so forth. So, let me give you a little information about Alex. Alex has had success in representing clients in all of the following matters: compensation and bonus disputes, actions for discrimination and retaliation, actions involving claims of hostile work environment and harassment, enforcement of non-compete, non-solicitation clauses, litigation for failure to pay overtime, improper wage deductions, and other violations of federal and state labor laws, negotiation and drafting of employment, severance, bonus, and other agreements, counseling of companies and individuals on various matters of employment law, including employee termination. So quite a mouthful there, and quite a lot of experience. And welcome, Alex.
Thank you. Welcome, Jim. Glad to be here.
Great. So why don't we just kind of jump right in with some different scenarios. So let me lay a couple of scenarios out for you and tell us how best to go about, for lack of a better term, dealing with these situations. So let's say I'm an employee and nobody's harassing me at work, but I just feel like it's time for me to move on and I need to search for a new job. Now, presumably, if I spend time while I'm at work on somebody else's dime searching for another job and emailing potential new employers, this could raise some sort of raise a red flag and create some sort of uncomfortable situations and possibly illegal situations. So what to do in that situation?
Well, I mean, the fact of the matter is that everybody pretty much does that.
Okay, right.
I think we've all been in that situation where we're using company computers to look for work, and we're emailing from our Gmail accounts to look for work. Companies usually, many companies, not all companies, do have email policies. They usually have email policies that specifically state that email shall not be used for personal purposes. You might be running afoul of those policies. Look, from a legal perspective, I've never seen a case involving somebody fired for engaging in, I have yet to see, I should say, a case involving somebody fired for your typical personal use of email here and there, a few minutes here and there. I'm not saying you should necessarily do that, but look, it's going to be a problem if you're spending all your time doing that, of course. And you are running afoul of various policies in that case. But you have to kind of use your best judgment in that case. I wouldn't go to an employment lawyer to necessarily pay an employment lawyer to advise me how to go about looking for work.
All right. Well, I think you just gave us good advice on how to go about doing that. So great. So now let's say you are in your current job and you feel as though you're being treated incorrectly by a boss or a coworker, and maybe whether it's a boss or a coworker would lead to two different ways of handling this legally. But what would you recommend to somebody who feels as though they're being mistreated by, let's start with the boss, and if you could kind of almost define what it means to be mistreated, because I'm sure there are a lot of people that feel they're being mistreated by their boss when in fact, they might just be being asked to do their job, and they might not like the tone that their boss is asking them to do it in, or some other reason they might be a little oversensitive. So, if you could differentiate between that and how to go about dealing.
It's a broad question, Jim. Mistreatment by a boss. It's hard to talk about this in the abstract. I would say that to be legally significant, there's a difference between what you just said, being asked to do your job,
right,
and something that becomes legally significant. The law, as you know, or maybe you don't know, but I think you do, because we talked about this before, the law in the US, the default is at-will employment. So you can be fired for any reason or no reason, with or without notice, as an employee in most situations. I think that applies to, I've heard the number, something like 90% of all employees. So in terms of mistreatment, though, the law does not actually make actionable or does not consider legally significant all types of mistreatment. The mistreatment that's going to trigger problems for the employer will have to be either something that constitutes hostile work environment, and that would be more than an occasional mean comment. That would have to be consistent, pretty egregious harassment that goes above and beyond your typical tough boss type of treatment. So that's one type. That's one category of mistreatment, is just meanness. Meanness that rises to the level of hostile work environment. Put-downs, personal put-downs, use of racist slurs. We definitely see that, unfortunately, still. But with a caveat that even an occasional racial slur has been found by some courts not to not rise to the level of a hostile work environment.
Interesting.
So that's one category. And the second category would be discriminatory conduct, discriminatory mistreatment or discriminatory treatment of employees. And that would have to be taking various what are called adverse employment actions towards employees based on some essentially more or less immutable characteristics. And you know what they are: race, gender, national origin, sexual orientation in many places. I mean, here in New York City, between federal, state, and city law, we have about 16 or so, on my last count, protected categories. Adverse employment action, what is that? This is the mistreatment you're talking about in this context. It would be anything from demoting somebody, firing somebody, certainly, but transferring them to a less desirable location, anything that adversely changes their employment conditions, including, of course, termination, but not just termination. It could be other things as well.
Interesting. So, Alex, maybe taking it to a little bit more of an extreme level, we are in the midst of this hashtag Me Too period, which is very unfortunate. And we do hear constantly stories of people that have been harassed on many levels, and they have gone to human resources departments within the company, and nothing happens because of the
politics.
Yeah, the power of the person that is doing the harassing. So what to do if you're somebody in that situation?
No easy answers, Jim. There's never an easy answer when it comes to employment law. There's always what can you do under the law versus what can you do practically, what is actually legal versus what is practically legal. And the ultimate question, of course, is what does the employee want? Going to HR is good because, in the sense that, well, first of all, it may actually solve the problem.
Right.
But secondly, even if it doesn't solve the problem, it's a good move because it creates a record. It creates, in a particular scenario you laid out, you have a record of somebody going to HR, and there's usually a paper trail associated with that because HR departments are, or at least good HR departments, are obsessive about record keeping. And in your scenario, nothing happened, right? So the person went, and no action was taken to remedy that particular treatment. So if it ever comes to litigation, that person would actually have a decent claim. In many cases, I mean, this is from the employer perspective. If an employer has an avenue, provides its employees with an avenue for bringing complaints of sexual harassment, of discrimination, of just harassment in general, and if the employee who's being harassed by a coworker, not a supervisor, but just a coworker, if the employee does not take advantage of that avenue, that employee actually, and then is subsequently fired or leaves, that employee may not actually have a case against the company. The company will then have an affirmative defense. Look, I'm sorry what happened to you, but you didn't take, but we had these policies in place. You knew about these policies. You never bothered to take advantage of these avenues that we offer for reporting sexual harassment. To return to the scenario you laid out, I'm sorry, I think I'm going off on a tangent here.
No, I think actually it's really good to hear different, I don't have the expertise in all the different scenarios that can unfold. So I think it's actually good to hear a whole, your take on this.
Sure, no. If you're facing that scenario where you've gone to HR and nothing has happened, I mean, look, you have a tough choice, right? You can leave the job, you can you can stay and put up with it. I can't advise somebody as to what they should do with their life. Litigation
Right.
is not something that's to be taken lightly. I wouldn't tell somebody, leave and sue them, because I don't know the person's situation. I don't know their financial situation.
Right.
I don't know their emotional state. I don't know how bad the harassment is. On the other hand, I would never tell somebody to put up with it either.
Right.
So it becomes an individual choice. But in the scenario you laid out, they would have a potential claim, based on what you said, against the company.
What, I'm sorry, maybe you actually said this before, but what about engaging with a lawyer while you're still there and outside?
Sure, you should engage with a lawyer, because the lawyer will give you options to consider and to weigh. And then you can make your decisions based on that. I mean, ultimately, look, if you're being miserable and unhappy, you should leave. Perhaps if in certain situations, what will happen is I will work behind the scenes with an employee to deal with this issue. I will literally help an employee draft emails to HR, for instance.
Why they're still employed, obviously. So
right, while they're still employed, outlining their concerns and pointing out that, look, I've taken advantage of the avenues provided for complaints. I've made these complaints on the following dates. However, these incidents continue to happen, and I've documented these incidents. And I'm at a loss as to what to do. My situation is difficult, and my work environment is being adversely affected. And if it's a decent HR department, if it's not just a bunch of hacks, and if it's not an overly toxic environment in the company, they should take action, because they should be therefore on notice, and they have their own legal department telling them that, look, we have a potential problem here. And the person may be, the boss may be transferred, or the person may be transferred, or some sort of a wall may be put up between that person and the harasser, or the harasser is disciplined in other ways.
Right.
But that is one thing you can do, is a lawyer could help you to engage in those kinds of negotiations behind the scenes.
Right. And I think like you were alluding to also, though, I mean, obviously once you kind of go down this route, your situation at work is most likely never going to be the same. Never going to be the same. Or
not necessarily. I mean, it's not necessarily true. Especially when you're dealing with larger companies with many supervisors, and if one supervisor is a problem, HR will accommodate. And if the HR feels like you really do have a valid concern, and HR has done their job and they've interviewed perhaps witnesses, I have definitely seen HR accommodate people by transferring them or moving them away from the boss.
You know what? That's actually really somewhat soothing to hear, that that you can work out for the better, and you can keep the job. And perhaps even HR will be using that information to build a case against
absolutely
laying off the perpetrator there as well. So
absolutely, yeah. I mean, look, big company culture versus small company culture, size alone can make a difference.
Yeah, good point. Really good point. Hey, so some other employee scenarios. Something that's actually happened to me a couple of times, unfortunately, the good old-fashioned RIF, reduction in force. So I've been RIFed from 2 publicly held companies, and typically when these things happen, there's a lot of people that get laid off, and people start talking, and someone inevitably always says, "Well, I'm not accepting this package. I'm going to go in and negotiate, or try to work something better." So what can you typically do in that situation? I have to say, when it happened to me, I certainly felt like, wow, I was never really a bigwig, for lack of a better term, but I just never felt like, hey, I could go in and renegotiate the package that they just gave me when I got riffed. It's like, here you go,
Right, right.
But I've heard otherwise. So
look, it's a good question that has many, many answers. Like everything in the law, the answers are always fact specific. But that's just a weasel way, I guess, that's me being a weasel lawyer. So
no. So
you can always negotiate. I mean, I think that negotiation is always possible, right? The question is always how much leverage you have. Before we even get to leverage, don't underestimate the power of pity on the part of the, or the power to elicit pity on the part of the reduced employee. I mean, people forget that, but employers are people too. And I've been in these situations myself, and I'm pretty sure, I'm just speculating based on what I saw, that people who had tough family situations were not reduced. So coming to your employer and saying, look, I understand you're offering me this package. I'm very sorry, but I have this and this happening to me. I'm a sole provider for my family. I've had a death in the family, or something like that. That actually sometimes is enough to get something extra. An extra 2 months of pay, an extra 3 months of pay. I've seen that. Believe it or not, it is possible.
So it's worth a shot. Hey, listen, it's always worth a shot, right?
That's absolutely right.
Always ask.
The thing is, ultimately, if you don't ask, you don't get. Always remember that.
Right.
If you don't ask, you don't get. So if you have nothing else to go on but pity, it may be worth engaging them in that sense. Now, look, if you have claims against the company, that potential claims, that gives you obviously more leverage. Although that's pretty rare in these situations. I mean, it could happen. People do have those claims. If you feel like, okay, you're being reduced in force, but that reduction seems targeted at people of a certain race or age, as is often the case, everybody over 40 or something, or disproportionately over 40, then you have, it's a different discussion. Then it's not so much about pity. Then you do have more weight, I guess, in that scenario. So it really all depends on what it is that the argument that you put forward and what the circumstances are of that reduction. But at the end of the day, like I said, if you don't ask, you don't get.
Gotcha. And certainly makes a lot of sense, but not necessarily any legal means of getting anything. Hey, so let's flip it now. Let's say you're a small business owner, and maybe you have a few employees that work for you. Mm-hmm. I mean, there could be a number of situations, and I've been in this situation as well, where I've had to lay off people. I owned a company that at one point I probably had eight or nine employees years ago, and had to lay people off sometimes for lack of performance in my mind. But what if you're in a situation where you feel like an employee is actually kind of stirring the pot with the other employees, and just
is a troublemaker.
Is a troublemaker, yeah. So what's the best way to go about laying off somebody like that without, and I've seen, if you lay me off, I'm going to go to hire a lawyer and so forth and whatnot. I mean,
right.
What do you do when you're in that situation, especially as a small business owner? One bad egg can really hinder any type of progress that you're making with your business.
You're absolutely right. One thing to understand from the employer perspective is the economics of employment law and employment litigation. In the employment world, in the employment litigation world, we see a lot more contingency lawsuits being brought, or contingency representation of plaintiffs in employment lawsuits. Contingency being where the attorney gets a third of any winnings or any recovery, but the plaintiff, the client, the employee typically does not actually pay anything out of pocket. So that provides that changes the dynamic, right? That makes lawsuits a lot more common.
Yeah.
Then the question is why is that the case? Why do we have so many contingency representations? And that has to do with various factors. One of them is that typically many of these violations of employment laws entail fee shifting. There's fee shifting provisions so that the loser has, or the loser employer in a case has to pay the winning plaintiff employee's legal fees at the conclusion of the case, which is pretty unusual in the law. I mean, not unusual, but it's special to the employment area of law. Oftentimes, the other thing is that the facts of the case are not overly complicated. And if they're not overly complicated, you can always find a lawyer as a terminated employee, or at least write a demand letter for you. It's not something like a patent lawsuit. I mean, imagine like an intellectual property lawsuit. Facts are much more complex. It's much more
research involved.
Right. To even write a demand letter in that situation will take a lot more effort. Here, you've been fired after being called a bad name. Great. I'll spend an hour writing a demand letter. You pay me something nominal, or maybe even nothing. And meanwhile, the employer who gets this demand letter is freaking out and hiring attorneys and has to spend money stressing out about this situation. So remember that, and realizing that, employers should be careful and should realize that every time you're firing an employee, it's just the case, you are increasing your chances of being sued. It's one of those increased risk events in the employer-employee relationship. Termination.
Right.
If you have a troublemaker and they're creating problems, you have to be careful. Let me give you one scenario.
Yeah, please.
Assume you have you're running a small company, and you have somebody who raises problems, and they've come to you and made a wild allegation of, sexual harassment, let's say, this person. Now, being a decent person, you're not going to reject this out of hand. You're going to investigate this allegation. And maybe you find from talking to people, because it's a small company, you don't email anybody, you just talk to people, that there's no basis for this allegation. It's groundless completely. And after determining that, you fire the person for causing you problems and for just hurting morale or what have you. You may have just earned yourself a lawsuit for retaliation. Because the law, when it comes to retaliation, basically doesn't care about the substance or the merit of the complaint. What matters in that circumstance is that somebody made a complaint, whether or not it had any merit, you retaliated against them for the mere fact of raising this complaint.
Interesting.
So people have to watch out.
Right. Employers
should watch out that what they're doing is not essentially penalizing somebody for raising the complaint. And the law is written in such a way so as to encourage people to bring forth. People should feel encouraged to bring forth complaints of sexual harassment.
Right.
Discrimination.
Right. Makes sense.
And so the appropriate and proper thing to do, it's hard to sort of talk about this in the abstract, but having said that, it would be for the employer to document any investigation that takes place, to perhaps have, in the first place, to have a handbook that provides for a procedure for bringing complaints. and like I said, to document any investigation that takes place, including any outcome showing that there was no, in this case, sexual harassment. And the other thing is that it may make sense in that case, as hard as it may seem, to hold off on terminating the person, to keep them employed and wait for them to do something else that's bad, that's not related to complaining, some further example of incompetence or something, to then fire them for that. Because if you're going to fire them right after the complaint is made, whether or not it's a meritorious complaint, you come off looking like you are penalizing them for raising that complaint.
Right. Makes perfect sense. So here's a question just popped into my mind. So say I own a small company. I have 2 employees, and the employees go not on work time. They're out for drinks at some other time. And I don't know, one of the employees gets a little aggressive with the other. Now, I would presume that's off of work grounds, not work hours. As the owner of that company, I would have no legal, I would be not liable for anything, and what happened off site between those two, if the woman was not happy with the way she was treated by the other person.
Right.
Doesn't necessarily have to be the woman, but I, as the employer, would have no liability. Correct?
Right. I mean,
I know everything. There's always a bit of
gray area, but I would think it's unlikely, right, that 2 people in their off time,
right,
who happen to be employees of the same company, get into a tiff.
Right. So, you know what? Let's go into an interesting issue here. Let's talk current events. We touched on the whole Me Too movement, but let's talk NFL football, because.
Oh no.
Yeah, well, and obviously this is a very complex issue on a lot of levels, and I actually don't want to talk about the political aspect of it, to be quite frank. But one thing that I've always wondered, as if I'm an employer, don't I have the right to dictate on a certain level how my employee acts, i.e., how they dress, how they act? If I own a restaurant, the waiters might have a dress code. They're not allowed to curse at guests. They're not allowed to sit down out in the dining room while they're working. So I've always wondered here, wouldn't that be a somewhat obvious way for the NFL owners that are getting a lot of backlash from people that don't think people should kneel during the anthem, even if, like, I might support them, but hey, you know what? Right now, you're my employee, and
right,
why we're in the stadium. I respect your right to protest, but
yeah,
right now, I mean, so the thing is, I don't hear people using that argument. I mean, maybe they don't want to for their own reasons, but
yeah. Look, I hear what you're saying, right? In terms of speech rights at work, in general, you don't have, in a private sector workplace, you generally do not have the right to free speech like you do away from the workplace.
Right.
There's an exception to that, and that has to do with talking about conditions of employment, like salary and so forth. That sort of implicates labor relations laws. But with that caveat, you generally do not have free speech rights. And you could be fired by your employer, technically, for saying something that the employer doesn't like, including perhaps not kneeling for the flag or not showing enough respect or deference to the flag or what have you. Now, whenever, however, but that's sort of as far as the law is concerned. But there is the political issue, and there's always politics, and this comes into play in things like discrimination lawsuits. You bring a case on behalf of a plaintiff who was terminated for discriminatory reasons, or for reasons that plaintiff considers discriminatory, and that's something out in the public. And it's public domain, right? And that company may not like to have this out in the public domain. The HR and management may be unhappy to have that in the public domain. So it may make sense for that company to settle this quickly, or to not even allow it to get to the point where a complaint is filed, even if that complaint or that lawsuit doesn't have that much merit. I mean, PR and your image in the marketplace do count.
Absolutely.
They do matter, apart from the law. And as an attorney, you have to think about that as well. How will this company look? I mean, think of it this way. Let's say there's an NGO, all right, or some sort of advocacy organization, liberal advocacy organization, and they fire somebody for purportedly discriminatory reasons, and that person is your client, and you send and you're the attorney, you're sending a demand letter to this advocacy organization. I mean, how are they going to think about this? They're going to say, well, we don't want to be known as this hypocritical liberal advocacy organization. We're for human rights and so on, and yet here we are facing a discrimination lawsuit. And this all factors into how companies and how employers approach these types of situations. It's not strictly law.
Right.
It's also what message that lawsuit would send about this company, if any.
Right.
And the NFL is concerned because, of course, the NFL is much more than just an employer. It's really a national institution.
Very complex.
With many African American employees or athletes, and these people have grievances, and therefore they're very careful about doing anything against them, whether or not they can take action under the law.
Right. No doubt. Very, very complex. I just it is somewhat fascinating. I think if you maybe look back on it a few years from now and look at it from the public relations point of view and the legal point of view, and wonder how best it should have been dealt with. But I don't know if there's a right answer, but
yeah, I mean, I right.
I
couldn't advise it'd be hard for me to advise the NFL, right?
Right. No doubt. So, hey, let's flip the switch a little bit and go off the uber serious conversation here about employer-employee relationships and so forth. And can you tell us any humorous situations? What would be the most interesting employee case that you can recall? Anything jump out at you as far as suits that somebody wanted to bring against somebody?
People don't usually come to me when they're happy, Jim.
Okay. No. I don't mean. I'm not saying it's happy. No.
No. Look, there are ridiculous things happen all the time. I had a case.
That's where I'm going. Not happy. Like somebody comes to you with like some ridiculous claim where it's just.
I actually was not the attorney on this case, but a very good friend of mine who's an employment lawyer was, and that was a case involving crotch grabbing. A woman was actually a female who had a female boss, and that female boss grabbed her crotch, and it was a large financial institution, and that case actually settled.
Sure.
So that's one example I can think of. I mean, I've dealt with cases involving fist fighting on the job between employees, which usually do not end well for anybody because both people usually get fired.
You probably both get fired, and one of them probably gets sued also for, I would imagine, by the other party. I lost my job and my tooth, and.
But then you're suing somebody who's out of work, and so I don't know if that's really a good outcome for you financially. By the way, there is in that circumstance, there's still exposure for the employer to the extent that they, for instance, knew about this other person's violent proclivities or tendencies and didn't do anything about it. So, you don't necessarily have no recourse. But I mean, those are the more ridiculous situations that I've encountered.
Right, right. Well, awesome, Alex. Thank you so much. Let me ask you, can you think of any major topic that we haven't touched on that you think is worthy of talking about for a few minutes, that people should be aware of, pretty common situations that might arise?
I think one that arises often is downloading of emails.
Oh, great.
Because it comes up a lot. I'm being mistreated. I have all this evidence of mistreatment. I want to download all the emails, my work emails, before I leave, and use that as evidence against the employer. It's a tricky call there, because first of all, by doing that, you are potentially running afoul of any of internal company policies. But that's less of a concern. And the main concern with doing that is you might be downloading and taking with you confidential or proprietary trade secret or customer information that has less to do, I guess, with your particular situation, more to do with the company business. That would set a company off and will make you, the employee, not look so great in any potential lawsuit. So before you do that, I'm not saying you shouldn't do that, but before you do anything like that, you should talk to a lawyer, perhaps, and figure out what the best way forward is. I understand the temptation. It is good to have that information when you're bringing a lawsuit. Attaching some of those emails to a complaint could be very powerful. It could frame your lawsuit in a nice way, but you have to be careful, because to the extent that they implicate trade secrets or other information that's proprietary, it could land you in other kinds of trouble.
Interesting. Very interesting. It definitely sounds like you could open up a whole other can of worms by, hey, you've removed trade secrets or right, company classified information. But that does make me think about some other questions for modern workplaces. And that is, hey, spending time on Facebook or LinkedIn or doing your shopping, while you're at work. And I know that every situation is probably different, and there are probably people that really abuse that. But can you give us maybe a little bit of a general guideline, maybe for an employee who is at work and surfing the internet on the company dime?
Yeah, look, you got to understand that.
Common sense is obvious. Right. It's got to be expected in this day and age that everybody does that a little bit here and there, and actually shopping online could actually end up saving the employee time and creating more time for them to be working rather than having to go out and do something. So,
just I would say be careful about things you post online, because employers increasingly are monitoring people's social media pages, and to the extent that the employee represents the company and is to some extent the face of the company,
right,
things that you say that might be offensive or inappropriate could be used against you, and you could be fired actually for things that you thought you were sort of doing in your personal life,
right,
out in the open. And because the concern is that, well, people will associate our company with these kinds of people. We can't have that.
Yeah. So even how about, hey, I'm wearing a hat with the company logo, and I'm posting a picture of me drunk with my buddies or something like that.
That's the kind of thing that, sort of very conservative answer that I'll give is that you don't want to mix business and pleasure like that. It's better to stay away from that.
Have common sense is basically,
exactly.
It really is. And it is amazing, though, the stories that you do hear or read about sometimes, and the lack of common sense sometimes that people exhibit with the things they post online or whatever it is. So, all right. Alex, thanks a lot for your time. Where can our viewers get in touch with you?
My website, they can go to my website, which is Sakin, SAKIN-law.com. My email, they could always email me at alex, ALEX, at Sakin, SAKIN-law, LAW.com as well.
Awesome. Thanks a lot for your time today. And this is Jim Posner and another episode of the Don't Panic Project. We provide conversations to help empower, inspire, and educate people suffering from stress, anxiety, and depression. You could check us out on my YouTube channel. Just search Jim Posner, or at www.thedon'tpanicproject.com. And I work with smart, forward-thinking people and corporations to help them harness the power of mindfulness to lower stress, increase productivity, enhance focus, and achieve a host of other scientifically proven benefits. See you next time on the Don't Panic Project. Thanks a lot.
Thank you.